Thanks, George. Good afternoon, everybody. Good afternoon to the people on the webinar as well. Happy New Year to everybody, too. I wish you the best in 2013. I hope we have a better one than we did last year. We're here to talk about public notification training today. You'll hear from the experts. Next slide. Can I do it? Okay. I want to thank our sponsors. We bring in refreshments every time we have one of these things, and the sponsors pay for it. We're getting more and more. In fact, I have to figure a way to get more logos on this slide because it's getting bigger and bigger, but that's a good problem to have. So thanks to the sponsors and thanks to the membership because the membership dues support us as well. Next one. Okay, for the LSRPs, the 4 tests are over. Thank goodness for that. We're all through that hurdle. But now we have to think about continuing ed every 3 years. When our next license renewal comes up in 3 years, we have to have 36 continuing education credits, CECs. And not only do you just have to have 36 credits by the time the 3 years are up, but you have to take courses in specific categories. And all the LSRPs should know what right now, the boards, the New Jersey LSRP board's regulations are in draft form, but I think it's going to be this way even when the regs are finalized. We're all going to have to take 3 CECs in ethics, 10 CECs regulatory, 14 in technical, and that leaves another 9 to use as you will to make up the rest of the 36 credits. So those are the minimum numbers you need for each category. Speaking about the board's regulations, I encourage all the LSRPs to also take a look at those draft regulations. The board is looking for comments right now. So if you're interested in how LSRPs, you as an LSRP, are going to be regulated as far as continuing ed, audits, disciplinary proceedings, and things like that, you should take a look at the regulations. And if you have a comment, write it into the board. They're interested in hearing from you. Next one. Okay, the way it works is most times you're going to get 1 CEC for every hour of instruction that you take. But sometimes people want to go to conferences, conventions, and workshops and things of that nature to get credit as well. But it works a little differently there. You can only get a half of a CEC for every hour you spend, and you're only allowed to get 8 credits for those kinds of credits. If you want to take a webinar, I'm not sure if they have any approved webinars yet, but if there is one, it's got to have a test at the end of it. And so you have to take a test in order to, that's the price you pay for sitting in your office and participating on a webinar. And it's a 1 hour, 1 CEC ratio there. If you want to give a presentation or you're writing a paper or something of that sort, you can also get credit for that. Next one. Okay, a little bit of a look ahead into 2013. Already we have something on the schedule. Ted Toscos, who's sitting right in the audience here, is going to run a breakfast roundtable for us that's scheduled for February 26th. Registration starts at 7:30, and we're going to talk about things that concern LSRPs. We're going to open it up to questions and answers, discussion, and what have you. This is going to be at the restaurant called Mastori's. I think everybody's familiar with that down here. It's on 206. You can register for this on lsrpa.org. Right when you see the home screen, there's a link you can click on for the registration for that. We're also going to continue our exam preparation courses. The next exam won't be for a while yet. It'll be in May. So right now we have on the schedule an exam prep course for May 7th. We did a business practice seminar in December for LSRPs. It talked about liability issues, insurance issues, contractual issues, and that went off very well. We want to have at least 4 of those a year, maybe on a quarterly basis as best we can. We're going to continue helping out with the guidance. You've seen some people at the registration desk. They're all with the LSRPA, and we help, and I do this spiel at the beginning of almost all of them. A practical applications course is coming up. We're going to help with that. We had an ethics course this year. A lot of people were not happy with it. Thanks, Dick. We got 7 credits for it, though. We got 7 credits. However, it was dry, it was slow, and everybody was pretty exhausted by the end of the day. So I think what we're going to do there is cut it down to a half a day and bring in some more local people. We had a guy come in from Colorado who was active in the AIPG and who had a lot of credentials as far as ethics goes. And that's why we brought him in as for the first course. We're planning a GIS training course as well. We're hoping to get Nick Sedano involved with that. And also, we're going to do something on the laboratory analytical process. There's going to be a new guidance document coming out on that soon. Hopefully soon. And we're going to try to time that course with when that guidance document comes out. And then there are a lot of courses established by entities who have been giving courses for a long time, like the National Groundwater Association and so on. So we're going to bring those in as well. Next slide. Thanks very much. We appreciate all the support we're getting from you, the members, and the sponsors, and enjoy the presentation. Thank you.
Thank you very much, Dan. Certainly appreciate that update. And up next, we have Karen Clue with an overview on public notification.
Good afternoon, everybody. Good afternoon to those of you on the web. Thanks. That one? Okay. I'd like to introduce myself, although George just mentioned that I am the manager of the Site Remediation Program's Office of Community Relations. For those of you who don't know, Site Remediation Program is the group within the agency responsible for overseeing the cleanup of contaminated sites. Currently, there's approximately 14,000 contaminated sites in the state of New Jersey. And these include everything from residential oil tanks to Superfund sites. My office was established about 20 years ago to act as a liaison between the technical folks in the program and the communities in which these sites are located. So I'm here to offer some reminders from the lessons we have learned over the past 20 years and to provide an overview of the changes to the public notification regulations, as well as some advice on how to handle public outreach and inquiries. So we have learned in the past 20 years that effective community outreach goes a long way in building trust and credibility with citizens and local officials. We expect that as RPs and LSRPs, you will have the same effect if you do public outreach in a proactive kind of way. We have also learned that absent facts, the public is able to speculate things about a site that are far worse than actually exist at a site. So if you arm people with the information that is accurate, they are often less likely to throw up roadblocks in the remedial process or the redevelopment process. We also have an increasing number of cases that require off-site access, either to do vapor intrusion sampling, potable sampling, or groundwater or soil sampling. Again, if people understand what is involved at a site, they are far more likely to grant access than if they are kept in the dark as to why you want to sample on their property. And it is required. Originally, the public notification requirements were established in the technical regulations in 2008. They were promulgated in response to an amendment to the Brownfields Act. What had happened was a local official contacted one of their assembly persons because they had a number of high-profile remediation projects in their community, and they felt that they were not being kept informed. In response, Assemblywoman Greenstein sponsored a bill to amend the Brownfields Act, which required the DEP to promulgate regulations requiring public notification and outreach. I'm going to speak about some of the changes that occurred when these regulations were moved out of the tech regs and into the administrative requirements for the remediation of contaminated sites, or the ARCS rule, at 1.7. As before, two categories of cases are exempt from the public notification requirements. They include homeowner tanks. These were excluded because they are typically low-risk, low-profile cases that are completed in a very short duration. Emergency response actions are also exempt from the public notification requirements because there's already a system of proactive notification to local officials when our Bureau of Emergency Response goes out. If an emergency response action requires continued site remediation involvement, then the public notification requirements do kick in at that point. When the rules changed with the promulgation of the rule package in May 2012, there were some overarching changes. Consistent with the whole new rule package, the prescriptive requirements were removed, allowing flexibility. The specific wording requirements that previously existed in the public notification requirements have been deleted, allowing RPs and LSRPs the flexibility to design language that best fits site-specific circumstances. Again, because RPs only have to report back to us at certain milestones under the new rules, and because there are no longer are DEP case managers assigned to every site, we will no longer have the most current information about the status of a cleanup in many cases. In most cases, the LSRP will be the individual in the best position to answer public inquiries. We have heard from LSRPs that sometimes there are confidentiality or contractual issues surrounding responding to a public inquiry, and we encourage those issues to be worked out. It is our experience over the past 20 years that when a member of the public is making an inquiry about the site, they're generally looking for very basic information. They're not looking for specific technical information. They're not looking for any kind of proprietary information. They're looking for a basic understanding of what's going on at the site that shouldn't violate any contractual or confidentiality issues in most cases. These provisions were not added in cases where there's litigation or anything like that. This is, again, general public inquiries. Because the department will no longer, in most cases, have the most current information about a remedial project, the requirement, ooh, what happened?
The handout doesn't have the slides.
Check one more slide, go one more slide.
It looks like only the odd couple.
Is that
pages that copied on the handout? I think it's too much in front of us.
Oh, I see. I'm sorry. We had a copying issue. I didn't check them.
So we'll see if we can try to get correct copies.
Okay. Can you advance it? Okay, going back. Okay, here we are. Thanks. Sorry about that. Again, because DEP will no longer have the most current information about a site and we no longer have a case manager, the requirement to include the Office of Community Relations contact information has now been replaced with the requirement to include contact information for both the responsible party and the LSRP of record for the site. We have heard from some LSRPs that they don't want their individual name on a sign. I can't blame them. So you can use whatever language will make it clear to a caller who they need to ask for to get information about the site, whether you call yourself the LSRP for the site, a project manager for the site, whatever the case may be, but some kind of identifier so when somebody from the public calls, they don't get the runaround. If you do not want to replace the whole sign, you can go to a printer and have like a sticker made up, like a bumper sticker, and you can make it the size of the contact information for the Office of Community Relations. So you simply just have to cover our information and put the LSRP's information on. And that will save you the expense of replacing the whole sign. Signs must be updated immediately. You do not need to send new notification letters out, if that's the method you chose, until the update letter is due. So if you're on the normal September clock, next September you have to send out your notification letters and include the LSRP's contact information rather than the Office of Community Relations contact information. So there's been some time frame changes in the new set of rules. This is a little complicated because it was done in error. Right now, the rules say that public notification must be conducted 14 days prior to commencing field activities associated with the remedial action. When the rules were originally promulgated in 2008, the trigger for public notification was the remedial investigation. This change was made due to a misinterpretation of the statute. So now that we realize the error, we do plan on revising the requirement. We have in the process of developing a rule amendment package that should go out when the UHOT rules are proposed. So the change will happen then. So if you elect not to do public notification until the RA at this point, that's fine. Obviously, we will not enforce against you. However, given that it's going to go back, you may want to just get it done at the RI rather than wait for the new change to happen. It's up to you. So within 14 days of the field activity associated with the remedial action, you have to send your letter, you have to post your sign, and you have to submit your required documentation to the clerk, the local health agency, and the CIHA, all at the same time. There's a time frame associated with getting that done. The documentation to us is currently required to be submitted with the next applicable remedial phase report. So that got a little complicated. So in the rule amendment package, we hope to go back to the old way. So when you do your public notification, when you submit your documentation to the clerk and the health agencies, you'll also give it to us together with the form. I think it's much simpler, especially if you have a protracted RI. You may have a sign up there for 5 years that we don't know about, and even though your name may not be on the sign, we still get the call. So it's kind of nice for us to know what's out there. So again, in the interim, we would appreciate it if you sent us your documentation when you do public notification. However, just to be clear, it is not required. It is only required to come in with the next applicable remedial phase report. This has been confusing to people since the original rules were promulgated. Signs and letters are required for all sites that get to the RI phase. Sites that have contamination that has left the property of the discharge also require a fact sheet to be developed, distributed, and published in the newspaper. So you have signs or letters for all sites, fact sheets for sites that have off-site contamination. The time frames associated with that is you have to prepare and distribute a fact sheet within 14 days of determining contamination has migrated off the site, and you have to publish that fact sheet within 30 days. You have to update, redistribute, and republish the fact sheet at the conclusion of the RI when delineation is complete. However, in the last several years, we recognized there was a lot of overlap for cases with groundwater contamination that were establishing a CEA. So what we have done is if your case involves only groundwater contamination and you're establishing a CEA, you need only follow the public notification requirements associated with the CEA. You don't need to do the updated fact sheet. We had also heard from a lot of responsible parties that it's very expensive to publish a fact sheet. Sometimes they're quite long. We recommend that you keep them to a single page, like front and back. Try and condense the information because anything longer, you'll lose them. But if it is very long, we recognize that it's very expensive. So we have developed some templates that are abbreviated versions of fact sheets that you are free to use to put the newspaper ad in that are much shorter and should go a long way to reduce the expense of publication. Another source of confusion has been the retail service station policy. After the rules were promulgated, we heard from the major oil companies that in many instances they do not know if a tank is leaking when they go to remove it. So they felt that they were going to go out in the field, they're going to pull the tank, see that it's a leaker, have to button up the hole, do their public notification, wait 2 weeks to continue the remediation. Obviously, this is in nobody's best interest. So instead, we decided that we would establish a 3-week time frame by which you could, if you're remediating a regulated underground storage tank at a retail service station, that you have to notify, either get your sign up or send your letters out, if that discharge was not already known. So we feel that this is a balanced approach. It balances the need to keep the public informed with the requirements to continue with a remediation while you're out in the field. RPs have always been required to conduct additional public outreach based on site-specific circumstances. And that has been in the rules since the inception in 2008. However, new to the rules is a requirement for a responsible party to respond to an inquiry either received directly by them or received by us and referred to them. This was added to ensure that responsible parties know that they are responsible for responding to public inquiries and concerns. Again, since LSRPs are usually the individual most familiar with the site, when we get a call, we will be sending that call on to the LSRP for public inquiry. And we will not track those calls unless we get a call back from that individual saying the LSRP did not respond or they responded inadequately. We will then ask the person making the inquiry to contact the responsible party directly. In the event they do not get a response from the responsible party, we can, after some compliance assistance efforts, take enforcement action. When we receive a written inquiry, either from a member of the public or from an elected official, we will forward that inquiry on to both the LSRP and the RP with a cover letter asking them to respond within a reasonable time frame and copy us on the response. Many of these inquiries from elected officials come to us from the 7th floor from the commissioner's office, and they need to know that loop is closed, that their constituent gets an answer to their question. Failure to conduct public outreach is a minor violation and can result of a base penalty up to $10,000, of $10,000, not up to. And that penalty would be assessed against the RP, not the LSRP. So again, having been in this position for a number of years and our office being in effect for decades now, there are some lessons learned. We have to recognize that SR speak is highly technical and specialized. The average member of the public probably would not understand a conversation between a case manager, inspector reviewer, and an LSRP. We speak in jargon, we speak in acronyms. When you're talking to the public, it really doesn't work. It just confuses them and frustrates them. So I would suggest trying to keep the information you're trying to deliver at a level that the average person can understand. It's okay to sacrifice some technical details to be understood. I'm not saying you make stuff up. I'm saying that you don't get bogged down in details so you lose the person making the inquiry. The caller, because they're unfamiliar with site remediation and the language we speak, they often don't even know exactly what they're asking for. So what I recommend, rather than having like a question and answer session with somebody making an inquiry, that you have a conversation with them. Try and figure out what it is that they need. And having a conversation, again, is a good way to establish a rapport with the individual. That being said, some calls require a great deal of patience to handle adequately. We have found that you always want to be professional, but you also want to try and engage the caller. You don't have to sacrifice being personable to be professional. So it's okay to laugh, to have a sense of humor with people. It's also okay to feel for people. If somebody is in a really tough spot, it's okay to acknowledge that they're in a tough spot and move on from there. I would say, I get a lot of callers who are quite frustrated. They can't get the answer they need. They've been bounced around either outside or inside a number of times. And and trying to build rapport with them and having a conversation with them goes a long way in disarming them. You can turn around even the grumpiest caller if you're just friendly and nice to them and try and genuinely help them. So even though you may not have all the answers as the LSRP, you may only be the LSRP of record for a certain number of areas of concern or a certain phase of the remediation, the caller is not going to understand that. They're going to think you know everything about the site, every detail about the site, and you're going to have to be patient and explain the process, that you are assigned to this, you can help them with this, you'll try and get more information, but you do not know everything about every site. I mean, there's an expectation from the public that the DEP was involved in all 14,000 sites and knew every day what was going on at those sites. It's not the way it works. It really never has been the way it works. But now with the LSRP program, it's even less so. But the ball is now in your court. If you do say, I don't know, and I'll find out, please honor your promise. Again, this builds trust and credibility, and respond promptly. People are depending on you to get the information they need. So just like here, there was a recognition that not all staff have the skill set or the personality to respond to these types of inquiries. So one thing you may want to consider in your firm is assigning certain individuals who do have these qualities to handle your public inquiries. Again, not required, just a suggestion. So above all, you want somebody who is patient, somebody who has the ability to summarize a situation without getting bogged down in the details, somebody who's friendly with good phone etiquette, and somebody who is courteous and respectful to the caller. Again, just advice that we have found that works in our program that you may want to try in your firms. We have a number of resources available on the web. We did update our guidance and our FAQs recently. I can't remember, probably a couple months ago now. So all of that should be up to date. We revised the form. I should have checked. I'm not sure if the revised form is up. I believe it is, but if it's not, that will be up shortly. But this is a list of web pages that are available. My contact information was on the first slide. I have to say, I get calls almost daily asking about the public notification requirements, so feel free to reach out to me if you have any questions at all. So at this point, I will open it up to questions.
Great. Thank you very much, Karen. We have 10 minutes for questions. I would recognize that probably your handouts are a little confusing. I just noticed that myself. We're working on that problem as I just detected it. But if there's any questions in the audience, we have a little bit of time now to go over them. Oh.
Yeah, I wanted to, first of all, confirm that the public notification requirements that were in the tech regs that are now in ARCs apply to the responsible party, not to the LSRP.
That is correct.
Now, question, most of the, like the focus of your talk is centered on the actual public, homeowners, concerned private citizens, maybe elected officials who have concerns about a specific site. And how do you view requests from other consultants or prospective purchasers who are looking for technical information about a site and basically trying to subvert the Oprah process?
I meant to mention that, and I guess I skipped that bullet in my notes. These rules are not intended to cover, I'm an LSRP, I want to get information from another LSRP because I think their site is really contaminating my site. That is not the intention of these regulations. We will take no enforcement action against the RP who does not release information to another LSRP for those purposes. It does not cover situations where there's litigation involved. These are intended to help the public, the general public, including elected officials and the media, get information about remediation projects.
So in those situations, the LSRP would simply inform the inquirer of the availability of public records through the DEP's Oprah program, and that would be the end of it?
Yes, we do have a provision in the rules, and this was out of the statute, that a municipality can request any environmental reports. Actually, the requirement says the responsible party has to provide any environmental reports to a municipality upon request. So in the event that they go through a municipality and persuade a municipal official to, but again, the intent of that is to, if a member of the public contacts an elected official, that is not, or the municipality, that is not intended to give one LSRP a route to get information from another LSRP. Those are private concerns. We do not intend to get involved with those.
Okay, another one from audience here. Oh, yeah.
Yeah, sorry. Just as a follow-up, though, to what you were describing, how does a municipality distinguish between a member of the public and another LSRP?
Well, I guess if the municipality makes the request, I would assume, and we would guide them if they asked, to ask, why is this individual making the inquiry? And again, all of these rules are intended to keep the public informed. If the first question asked is, in what way do you intend to use this information, I would think it would come out pretty early that the person was using it for reasons other than to keep the public informed.
Okay.
Okay, let's take one off the web here. It's from Keith Conlon. It says, are we required to share our project files if requested? This type of request was made to my office from another consultant. This seems to be the task of Oprah, which
we kind of just covered that. Yes, I agree that it is an Oprah process.
Okay, next one is if the responsible party only wants the LSRP contact information on the sign, is that acceptable?
Yeah, we have had that request, and an LSRP can, we don't use the term variance anymore, but grant himself a variance. We've had cases where, especially like big corporate firms, like we don't want people to have to call Exxon headquarters in Texas to get an answer. So in many instances, they've asked whether the LSRP can be the point of contact for the sign. Sometimes they elect to have a local attorney act for the RP. So, yeah, we want it to be as practical as possible, and the contact information included in the public notification, sign-in letters, be the easiest way for people, the public, to get information.
Next one is in regard to public notification. It says, when is proof of publishing in a newspaper required to be submitted to the NJDEP?
You know, I'm going to have to double check that. I'm not sure where that is in the new rules. Oh, it is in the new rules. It did make it in. But I have to check the exact when, whether it's 14 days after putting the newspaper ad in or something. But it is in the rules, and there is a specified time frame that you have to give us all the documentation. No, I'm lying. It has to come in with the next applicable remedial phase report currently. When the rule amendment changes, it's going to be at the time you place the ad. So what it's going to say is something like, within 30 days, you have to provide your fact sheet, prepare your fact sheet, distribute your fact sheet, publish it, and provide the documentation to the local officials and to us. So it's going to be a broad time frame by which you have to accomplish all of that, but it should be sufficient time. So I'm not sure whether it's 30 days or 60 days. But right now, you only have to provide that documentation to us with the next applicable remedial phase report.
Okay. Other questions in the audience? Okay, seeing none, we'll take another one from the web. It says, during the course of UST removal and discharge, during the course of UST removal and a discharge is discovered, is the 3 weeks for public notification only applicable to retail gas service stations, as the slide header says, or is it for any regulated UST removal?
Well, this policy was implemented in response to the major oil companies encountering this circumstance apparently frequently. I would say that it would make sense that if it applies to them, it could apply to other regulated tanks as well. So perhaps I'll take a look at what's on the web, and maybe we will retitle it.
Okay, another question. Karen mentioned residential UHOT exclusion. What about UHOTs at commercial sites? Also, does retail service station policy apply to all regulated USTs or only at service stations?
We've kind of covered the second question with the last question. The UHOT exclusion is, I believe, only for residential tanks. But I will have to double check that in the rules itself to see how exactly it read. But I believe it's only residential unregulated heating oil tanks. But I will confirm that, and we could put something on the web.
Okay, let's take a couple more and then we'll move on. I am a consultant for an RP. In the past, we have addressed inquiries for the RP. Can we continue to put our firm's contact info on our sign along with the LSRPs? Or does the client, which is the RP, need to include their contact info on the sign?
Well, again, we kind of addressed this earlier, but we want the contact information on the sign to be the contacts that make it easiest for the public to get information. So if it's not appropriate for the RP's contact information to be on there, the LSRP can make the judgment call that it is appropriate for some other firm and themselves. It is, again, we want it to make sense and we want the points of contact on the sign to be the individuals best able to answer public inquiries.
Okay, so they do have flexibility in
Yes.
it. Okay. Next one is the fact sheet only needs to be updated when the offsite extent is completed and not every 2 years like public notification letters, correct?
That is correct.
Good, that was an easy one. I like that one. Then we'll move on to another one. What reports, RI, CEAs, are required to be submitted to municipalities as part of the public notice requirements? And is that only upon request?
Yes, that is only upon request. The original draft of the amendments to the Brownfields Act required all environmental reports to go to municipalities. When we talked to the assembly person sponsoring the bill, we persuaded her that would be in nobody's best interest because oftentimes these reports are very voluminous and very technical, and the person wouldn't understand it. It would take up a lot of room at the municipal library or in the municipal clerk's office. So instead, it's only upon request.
Okay. Another one, in the case of a condominium located within 200 feet, is notice to the condominium association sufficient? If notification is required to individual unit owners, is it sufficient to notify only the units within 200 feet?
We actually have an FAQ that covers this. You have to notify all the individual condominium owners and all of the owners on the lot that is within 200 feet. So you don't say, okay, units 1 through 5 are within 200 feet, but 6 through 10 are not, and therefore you don't have to notify 6 through 10. You have to notify them all. If the lot that the condo sits on is within 200 feet of the contaminated site.
Okay. Just checking in with the audience again. There's a question over there. Okay.
Is there a timing on the rule amendments?
Barry?
Hold on just for a second, Barry. We've got to get you. Can you get Barry the microphone? This would be Barry Frasco, esteemed Assistant Director of HSSC. Barry?
I don't have a specific time frame, but my understanding is the rule package is down for final review with the Office of Legal Affairs, which would mean it's probably 2 to 3 weeks time before it gets to Office of Administrative Law. So we're probably talking a month plus, but that's all approximate.
No commitments.
That's the best I can do.
Okay. Other questions from the audience? Here we go. One.
How does an interested party identify and validate whether an RP is in violation of public notification and outreach? And if so, where does he or she, or to whom does he file his complaint? And would there be someone that would do further inquiry into this situation?
What we would ask is, we would ask that the person who has not had their inquiry responded to provide us with something in writing, either a letter or an email, documenting the dates that they reached out and to whom they reached out, whether they got a response or whether the response was just inadequate. But we do need, if we're going to pursue this for enforcement, we do need some documentation. Our first effort, though, would be to reach out to the remediating party and try and facilitate getting these answers to the person making the inquiry. In the event that compliance assistance effort fails, then we could refer the case to enforcement. The individual you should contact is myself, and my contact information is on the front page.
Okay, let's take 2 more from the web, and then we'll move on. Did you have something? Oh, hold it. We do have one more here.
Just with the time frames, I know it currently says within 14 days of remedial action. So if you're in the PA or SI phase or even the RI phase, you don't have to submit, do the public notice, right?
Correct.
Okay, one more from the web, and then we'll move on to Heather. This question is, my site has several LSRPs. Must be a good-sized site. So what do you recommend in regard to listing the information on our signs?
I guess I wouldn't recommend listing a whole bunch of people because that'll just confuse public. If they're all LSRPs, well, I guess if it's LSRPs all working for the same firm, that's kind of easy. You just agree who's going to be the point of contact. If it's LSRPs for from other firms, I would recommend that you get together and decide who the point of contact is going to be. If the question then falls outside your purview, you can then refer them on to the appropriate LSRP, or some kind of arrangement like that. Obviously, the person on the sign has to be able and willing to handle these calls. If they're not able and willing, then you're going to have to list them all.
Great. Thank you very much, Karen. We're going to move on. Please join me in thanking Karen for the presentation. Okay, great. Next up, we have Heather Schwartz, who's giving us a presentation on helpful hints on effective communication. So Heather?
Hello. My name is Heather Swartz. I've worked with the Office of Community Relations for 21 years, and I was asked to speak to you tonight to impart some of the collective wisdom of the Office of Community Relations, which has actually been in existence for about 25 years, contrary to what Karen said. I'd like to emphasize the title of this presentation is Helpful Hints for Effective Community Outreach. You should consider most of the material I cover tonight recommendations and suggestions, tips, pointers, words to the wise, with the exception of one slide that I'll get to fairly late in my presentation, which covers some requirements in the technical requirements for a site remediation rule. But other than that, this is all just recommendations that we hope you find helpful. Okay, so let's see. Okay. In addition to public inquiries, which Karen just covered, the most common types of community outreach activities that we conduct in the Office of Community Relations is outreach related to residential sampling and the dreaded public meetings. Residential sampling can take form of potable well testing and vapor intrusion testing, which has become fairly common in the recent years. And less common, but every once in a while we will do soil and or groundwater testing at a residential property. In that case, we may need to get onto a residential property to conduct soil delineation or install and sample a monitor well. So the common outreach activities are arranging sampling appointments with the property owners and or tenants, collecting samples, reporting the findings to the property owner, the occupant, which could be a tenant, and the local health officer, as well as facilitating remedial actions. And this might be installing a treatment system on a contaminated well, installing a subsurface depressurization system at a house with a vapor intrusion issue, or it could mean implementing a soil remedial action at a site, at a residential property next to a contaminated site. We have found that the primary concerns you'll encounter when doing residential sampling are, first and foremost, possible health effects. When residents express concerns about possible health effects due to a site, we always refer them to the local health officer or the state health department and provide them with a name and phone number. A close second is their property value. How is their property value going to be affected by the site? Usually we have a hard time providing a good answer to that because you don't have insight knowledge to the what's going on in the with the realty situation. Usually I have pretty good luck. If I know homes are selling, I will tell them that I have noticed that homes have sold in the area. Usually we can't speak to the property values itself. And third, less common, but occasionally does happen, we get residents that are concerned about confidentiality issues. They feel there's a stigma attached to living in a house with possible vapor intrusion issues or a contaminated well or contaminated soil. And they just don't want us advertising to the community that they have a problem. Again, this is not a common issue, but we do occasionally encounter the resident who is really concerned that we do not provide this information to anyone else. So therefore, we treat all information that we receive with the most confidentiality we can. Technically, all the information is part of the public record, and if they filed an OPRA request, Open Public Records Act request, they can get that information, but we don't provide it to other parties upon request. We make them do a file review. When it comes to obtaining access for residential sampling, in the past, my office, the Office of Community Relations, used to help LSRPs obtain access to properties in order to conduct vapor intrusion testing, potable well testing. As of May 2012, with the full implementation of the Site Remediation Reform Act, we can no longer provide that assistance. It's really up to the LSRPs and the RPs to gain access to the properties. But we have done is provided on our website optional property access template letters that you can use, and there's the link that you may go to get these template letters, otherwise known as shell letters. I think there are 5 letters in that package. One is an introductory letter simply stating, hi, we'd like to sample your property. The remaining letters are in cases where you have difficulty obtaining access and you are making your second, third, or fourth attempt to gain access. And actually one letter is requesting access to install a system, a remediation system. This only applies to vapor intrusion. In the next few weeks, I hope to get potable well versions on the webpage. But if you need potable well version access letters now, you could take the vapor intrusion template letters and modify them. It'll probably work fine. Okay. So arranging sampling appointments. The first step is the introductory letter. Like I said, there's a template available in the property access letter templates on the web page. Send several weeks before the sampling event. I like to give 6 to 8 weeks before the sampling event. And explain the reason for the sampling and provide general information. We always include a fact sheet about the site and any other relevant fact sheets. For example, if it's a vapor intrusion testing, we'll include fact sheets regarding vapor intrusion and how vapor intrusion issues are remedied, that sort of thing. For rental properties, you want to send it to the occupant, otherwise known as the tenant, if there is one, and the property owner. And we always give the local health officer and town clerk a list of the individuals contacted. We strongly recommend that you do that. And you get the health officer on board early, and the town clerk would refer it to the mayor or the business administrator. And in case you need their help in the future, you already have them on board. Step 2 is a phone call or email to the occupant. We give at least 2 weeks' notice of the sampling event. I think 3 is the best, optimal. Be prepared to discuss sampling details and when they'll get the results. And for vapor intrusion testing, it's a good idea to review the instructions for occupants' indoor air sampling. There's no similar instructions for potable well testing, but there is for vapor intrusion testing. Once you get there to do the sampling, it's good if someone is available to answer questions. If no one is available to answer the technical questions about the site, please give the occupant or the property owner a phone number of somebody that they can call. And we think it's a good idea to defer to the property owner's wishes whenever possible. For example, if they don't want a sample collected at a particular point for some reason, please try to accommodate that. It's never a really good idea to get in an argument with the homeowner because they could withdraw their permission to do the sampling. And this also applies when doing a remedial action. Say you're installing a vapor intrusion testing system and they would like some modification to the system in order to make it less obtrusive. In that case, we suggest you, whenever possible, you accommodate those wishes. Reporting sampling results. You must, by regulation, provide written notification of the sampling results to the property owner, the tenant, and the local health officer. But we recommend providing verbal notification if the contaminants of concern are very high. The rule of thumb that we use are more than 10 times the standard or the screening level. I'll give them a call and let them know before the letter actually goes out that we found a really high level so they can act accordingly, drink bottled water, or do something to ventilate the vapors from their home. I will also call them if there's very high levels of non-site related contaminants that we find. This might happen if the occupant of the house is engaged in some sort of hobby that produces fumes. That's pretty much the only time that I've encountered this problem. And when more than 2 months has elapsed since the sampling occurred, if there's some delay in getting the report out to the residents, I'll give them a call and let them know, even if the levels are low, just to, because I think they appreciate that. This is the one slide which I mentioned earlier, covers the non-optional outreach activities. Written notification is required by the TEC rule, also known as Technical Requirements for Site Remediation Rule. Written notification must include a cover letter that explains the findings in non-technical terms, a table that clearly summarizes the analytical results. We do not recommend sending raw laboratory analytical tables. They're just way too complicated for that lay person. Occasionally we get a resident who has a scientific background who asks to see those tables, and whenever possible we do provide them. But for most residents, it's way too technical. So we do not recommend providing those. We prefer a simplified version, which I'll get to in a minute. And the letters by rule must go to the property owner, the tenant, and the local health officer. Template sampling results, letters, and tables are available on our webpage. For vapor intrusion, the link is provided. Those have been there for a while. I should note that we're in the process of updating them to reflect the new screening levels that just came out, and they should be updated within a few days. I think by early next week, the updated version should be on the web. And just as of yesterday, we have potable well template letters that includes letters and tables, and there's a link for that. These letters are not perfect, but they do cover, I think, the vast majority of the situations. And I just want to stress that if you have any suggestions for improvement, my contact information is included on the first slide. I'd be happy to hear from you if you think that you have some suggestions to improve any of these letters. And that goes for the property access letters as well. Public meetings. Typically, most sites will not require a public meeting, but if you find yourself in a position that you think a meeting is necessary, we suggest holding the meeting earlier rather than later. This is to ensure maximum transparency, and it also allows you to get ahead of any negative messaging that may come from, say, members of the community or the media that may want to put a negative spin on what you're doing. And we also suggest that you meet as often as needed to ensure timely conclusion of activities. Generally, there are 3 possible formats for public meetings that we have used over the last 25 years. The first is a local council meeting. That's when you tag along at a local town council meeting. You get on their agenda for the evening. The town runs the meeting. You're there. You provide a PowerPoint presentation. We always provide fact sheets for the attendees, and we answer their questions. Very informal. The second is the formal presentation with question and answer period. This is what most people think of when they think of a public meeting. It's held at a local venue close to the site, generally the auditorium of a high school or the municipal building. There's a panel of experts that give a presentation. And there's a question and answer period. And we always provide fact sheets there as well. And then the third is what we call the public information session or public availability session, and also known as an open house. These are held over a 3 to 4 hour period, late afternoon, early evening. And you have charts and maps available, fact sheets as well. People come in and ask questions at their convenience about the site, and typically there's no formal presentation. Now, I just want to spend a few minutes talking about the public information session versus a public meeting. We have found in our experience that public information sessions are really only appropriate under very limited situations. In fact, we'll only really hold public information sessions when we're ready to start a remedial action, such as a capping of a landfill or installation of a groundwater remedy. It's at the beginning of a remedial action. People then can come and ask questions that are relevant to them. For example, when will you start warming up your trucks in the morning? Will the trucks be going past my house or where the kids walk to school? How will you be vegetating the site? It's really not appropriate to hold a public information session at the beginning of a remedial investigation. That's the time most people want a formal presentation with a panel of experts, a PowerPoint presentation, and a question and answer period. When you hold a public information session in lieu of a public meeting early in the process, people do sometimes get upset. I've seen that happen. It was not a good outcome. We've had a couple of situations recently where that's happened, and people feel that they want to come and they want to see what everyone's questions are. They don't want to just answers to their questions. They want to have answers to everybody's questions. And they also feel that when a public information session is being offered instead of a public meeting, when it's appropriate, that it's an opportunity to divide and conquer if the site has a potential for being controversial. And in fact, in a few moments, we're going to run a clip of a video from a recent case in Paulsboro where a government agency opted to hold a public information session when a public meeting was the more appropriate option. And the last thing I want to say about public information sessions in general is sometimes people will come and expect a formal presentation, even though you try to explain it's just an open house. They'll still come for a formal presentation. So what I've done recently is include a small PowerPoint presentation midway throughout the public information session, and that seems to work fairly well. Okay, so I'm going to ask Joe Eaker to run the clip of the Paulsboro video. Yes, I'm ready now.
Action News reporter Kenneth Moten is live in neighboring Gibbstown tonight, where they held a contentious meeting. What happened there tonight, Kenneth?
Jim, this open house definitely didn't go as state, local, and federal officials planned. A half hour before the doors opened here in Nahanzi Middle School, there was a line wrapped around the building with people who were looking for answers. It was a gym packed with hundreds of frustrated Paulsboro residents.
What he's saying is not true.
There were people with questions about the evacuation zone.
But we're wondering why those people that are so far away have been evacuated and we have not.
And there were those with growing health concerns.
My son has been coughing like crazy since this all happened. I've been lightheaded, dizzy.
Residents were supposed to walk from one table to the next, learning about air monitoring, public health, and community assistance from EPA, Coast Guard, and Conrail officials after last week's toxic train derailment. It turned into confrontations.
This is crazy. Crazy.
Right.
Talk about aggravated.
That system didn't work that well, right along with the loudspeaker, which kept cutting out. The technical problem only pushed the rising temperatures of this crowd of more than 500 higher, as those who haven't been evacuated